The Firm, India's only show on corporate law, tax and audit matters.
Hello and welcome to The Firm. On the show this week, an IP skirmish and a tax battle. All he did was run a Flipkart versus Amazon poll. Why then has Flipkart accused this tech blogger of trademark infringement? FPIs have won some much-needed relief. But why is CBDT cherry-picking from the AP Shah report? Our top story this week is a classic David versus Goliath tale. It involves a 20-something-year-old tech blogger. Now, all he did was run a Flipkart versus Amazon poll online. Why then has Flipkart accused this tech blogger of trademark infringement? Should we be yelling intimidation, fair use, chilling effect? Or is Flipkart justified in such IP protection? Ayush Alawadi finds out.
Imagine waking up one fine morning to find out that one of the country's largest e-commerce companies is accusing you of trademark infringement, copyright infringement and cyber squatting. Well, that's exactly what happened to Amit Bhavani. Hyderabad-based Amit Bhavani runs tech websites like Phone Radar and Android Advices. He reviews and compares smartphones, smartwatches, applications, operating systems and other technology. Last month he launched a website called Amazon vs Flipkart.com to conduct a poll comparing Flipkart and Amazon India on a number of counts such as service, interface, product portfolio, discounts, deals, returns and replacement policy. He also used the logos of Flipkart and Amazon.
Being a blogger, I keep reviewing smartphones and I had a doubt like which website, probably Flipkart or Amazon, would the users would be more interested in. And it was just a fun poll which I created on a website called Amazon versus Flipkart, and there was nothing specific in it. There was just a simple website which had a simple poll asking users to vote on a few factors like in terms of design, in terms of pricing, in terms of the customer support and a few other factors like 7 to 8 total factors. I just asked a few questions and there was no commercial activity behind it.
But Flipkart wasn't amused. The company sent him a cease and desist notice accusing him of trademark infringement, copyright infringement and cyber squatting. In a strongly worded letter, Flipkart asked Amit to take down the website within 7 days, barring which it would take further action. It was the first such notice that Amit has ever received in his life. So, he immediately took down the website and informed Flipkart that he had done so.
This was no way part of my business, so I thought it's better to not even take an initiative to fight with Flipkart. But again, thanks to all the support from other people in the industry, they have told me that this is actually wrong and what Flipkart has done is a very strong thing which they have done against me by sending this legal notice.
In its response to our query, Flipkart admits that the language used by it in this notice is strong, but it also insists that Amit's website violated its goodwill, brand and trademark.
I'm still shocked at what Flipkart has done, and I'm still worried what would be the consequences considering that the notice, and they have not even acknowledged the fact that I have taken the site down. They have not even acknowledged the fact that I have sent them a mail, and the Corpcom is just responding to some stories on the web, but this is not happening actually. I mean, now what's about the freedom of speech? I cannot even write about them anywhere, and can't I do a fair comparison of their service with the other brands? I mean, this is something which lawyers should actually help me out, or probably help the whole community in understanding that what would the fair use be, and what all other kind of content which I could publish on the internet.
Well, then let's bring in the lawyers to find out if what Amit did amounts to fair use of a trademark or not. Abhishek Malhotra is an IP law expert and managing partner at TMT Law Practice in New Delhi. He reckons that Amit could have used the doctrine of fair use as a defense.
Fair use is usually employed by, let's say, for the lack of a better word, a proposed defendant or a defendant, someone who is defending that particular action, as a use which is not really impinging upon the commercial interest of the party concerned, but in this specific case being used more for a fair comment or collecting some evidence in terms of how popular a particular website or a product or a service is. In that relation, it could possibly qualify as fair use, and it is what we refer to in trademark law as nominative fair use. You are using the nomination of that particular trademark in a fair manner to communicate a particular message. Similarly, in copyright, there is an entire provision of under section 52 which talks about fair dealing. That's the language which is used under the Act, and there also you have a possibility of using an artistic work in relation to a fair comment. Now, how much of that is a fair comment, what is the amount of usage that ought to have been taken for it to be construed as fair dealing or not, is something, of course, that could be considered in the circumstances by a court of law. But in this instance, given the fact that his poll was not sponsored by either of the two parties, it seems that it may have been just done at his own instance for his own academic interest, and if he could demonstrate all of that, then it's definitely a fair use.
Delhi-based senior advocate and well-known intellectual property lawyer Pratibha Singh sees nothing wrong with Flipkart's notice. In fact, she says the use of Flipkart in a domain name could justifiably worry the company.
From the way I look at this notice, I think because the man is using Flipkart in his domain name, it's a regular or routine notice to protect the mark. I don't think they are intending to kind of intimidate anybody. They have a problem with the domain name being used, because somebody could be directed to that domain name while he's looking for Flipkart, right? If he's looking for Amazon, he may be directed to that domain. If he's looking for Flipkart, he may be directed towards that domain. So I think this is a routine notice which was sent by Flipkart.
But Amit maintains that the website was a research tool and nothing more. He took it down immediately because he didn't want to battle one of the country's biggest e-commerce companies.
It's just the fear. What happens when you get the first legal notice in your life and for no reason? If it's for my own actual business, I would have fought for it. But this was something which was just for understanding, or you could say a fun poll. There was nothing about it. There was no business behind it. And why would I fight for it? And then later I realized I shouldn't have taken it down and I should have fought with Flipkart. But again, I don't really know the consequences, considering we are fighting with a giant, and this is India's one of the biggest startup company.
If Amit had just used the word Flipkart, maybe he would not have received this notice, because of the fact that the logo was also used, which was not necessary for the purposes of sending out that comment. But in today's day and age, maybe when people see the logo, they immediately, what springs to mind is that the comment is about Flipkart. So in a sense, the answer is that it may help people to take a conscious initial search or research about what they can and what they cannot use. So in that sense, it is not too bad, but if these instances proliferate, they could result in a chilling effect.
Chilling effect refers to legal action taken to silence journalists. So does this mean that all journalists need to be wary while reporting about Flipkart? Should I even be using their logo right now?
Genuine news reporting can never be violation of a brand, right? So if you're using Flipkart on your show to discuss the issue, then that can never be illegal use of the mark, because you're not promoting your business on the basis of that. Whereas a website which is created, for example, Amazon versus Flipkart, tomorrow you may do Maruti versus Hyundai, he may do Pepsi versus Coke, and then he may create a business model out of it. So there are things you have to safeguard against. Obviously CNBC doesn't fall in that category. CNBC is a genuine accredited news channel, right? But every other blogger or every other website owner need not be like CNBC.
That's good to know, but what if Amit hadn't taken this website down? Would Flipkart have sued him, or was this notice just meant to intimidate him?
It is unlikely in most of these instances that the company would take action against an individual in a court of law. They would rather which is why the company has sent out a legal notice to begin with. And if the company really wanted to take this person to court, then they could have done that immediately. They need not have first sent a notice and then waited for whether or not there is compliance of that notice, then to wait and then file a suit. So I think it is something which is more to send out a message that we are a company which is interested in protecting our intellectual property rights, and therefore we would like people to respect the same.
In an increasingly digital world, enforcing one's intellectual property is a tough task even for India's new age companies. For now, Flipkart may have succeeded in protecting its intellectual property online, but as IPR awareness increases, it'll be interesting to see how companies will tackle such cases. In Mumbai, Ayush Alavadi.
All right, from an IP skirmish to a big tax battle. Up next on The Firm, FPIs have won some much-needed relief. But why is CBDT cherry-picking from the AP Shah report?